There are two applications.
Where are they?
There are three applications.
At least I know, Deborah will mention one.
Yeah.
We are actually bringing them even, one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one. The other one, Deborah. Yes, my lord.
We'll deal with the application before us.
My lord, very please you.
The application for empanelment in this bench.
Where's the application? Empanelment.
Yes.
And perhaps, my lord, perhaps before you give the directions, with my lord friend, Ms. Kimotho, she's informing me that she was not aware of directions in the morning that applications be filed and we come back before you. And now her petition has been integrated in the consolidated petition. That is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her similar application if she so wishes. Because now she's participating in a proceeding, she did not directions.
Council, listen to this and listen to this very carefully. All of us acknowledge
The momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll make a ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us are very okay. But let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, Judge Mureba will give the final issue directions on time.
Okay, this is how we'll proceed. The applicant.
This is only one applicant.
The applicants will have 20 minutes to argue their application. Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to respond to the application.
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves of the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please? The client, I and my colleagues represent is the subject of the removal, is the subject of his pleas to this court. The application for the constitutional bench is made in E015 by my friend Ibamungai, so that effectively the subject matter of removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
10 minutes. I would have said 20.
minutes. You have 10 minutes.
Thank you.
My Lord, can I be heard? Can I be heard?
Yes.
My Lord, I received the instructions yesterday from Gachagua here. Oh, I'm sorry, I speak loud. I received the instructions yesterday from Gachagua here that I come and make an application that Gachagua would like to be enjoined to this matter. We all know Gachagua. We can't pretend that we don't know Gachagua. And we know the role Gachagua has played in advancing jurisprudence, constitutionality, and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen quite a number of things which I may not be able to say if I'm representing Gachagua.
That is okay.
Thank you very much. May I then comment on one small thing, my thoughts? My lords, the country is in a crisis. There's a constitutional crisis. There is a national crisis. And our coming to
That is correct, isn't it?
My lords, may I say, I have taken the trouble to read this constitution of Kenya. I have taken the trouble to read the constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that Kenya, we can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had.
Dr. Kavuna, we made proposals and we gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want to ask everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This should be part of the healing process of the whole country.
Dr. Kavuna, I ask you.
Yes.
We have given directions on time.
Your hands are not tied with respect.
Okay, tell us,
we can always-
just tell us, in your view, how much time do you want us to allocate parties?
What I'm saying to the tremendous respect, my lord, we talk about time in civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr.
And
Kamino.
let
What
Paul
we'll do-
Meter be given as much time as he wants.
Let
the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutajo Makinata, kifua mbele na matako nyuma. Yeah.
Okay.
Let us do that. Let us go time. Where are we going? Where are we going with? Please, I'm speaking. Will you speak, sit down? With respect, will you sit down, please? Kamino is talking. Will you sit down? It doesn't matter what you call yourself. Would you sit down, please? Yeah. Yeah. I am talking. I have got the floor.
Dr.
Under the rules of this court,
Yeah.
senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down, I as senior
I
counsel.
will not speak down. Will not practice.
That is not the So
Don't give yourself serious title to be deserved. You are doing serious.
Excuse me.
You are doing breastfeeding. Don't give yourself title which you don't deserve. My Lord, what I'm
Dr.
saying to
Kamuna,
you.
finish what you're
Yeah,
saying.
what I'm saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we hurrying for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when it comes to
I
jurisprudence.
think
Yes. My Lord,
they mean something, Dr. Kamina. They
What?
do mean something. Those
something means something when it is you and you approve it. Yeah. My Lord, all that I'm saying to you, let people talk. Let people address you.
Okay.
Where are we going?
People will talk.
When
but
the country is burning.
Dr. Kamina, you have made your point.
Yes, thank you very much.
You have made your point.
I have made a point. Yes.
Professor.
We have a deputy chief justice who has been removed irregularly. Let us be given time to be able to address you. Thank you.
I think those of us who are representing substantive respondents, we all agree that you have given orders that we will comply with, including my learned senior PK Moite, who I believe you have added some more time and is happy with that. Maybe it would help if it's not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on empowerment. That's all I wanted to clarify.
So, Dr. Kamina, I've heard what you said.
Thank you very much.
We'll stick to the time allocations, but in the event that one party needs more time, they will tell us.
Well, when we come to substantive matters, let people
I
say what they
agree
want
with
to
you.
say.
I agree with
Yeah.
you. Thank you.
Where are we heading to?
Thank you.
Yes. Thank you.
Madam, in view of that time allocation, and I thank senior counsel, the senior most going by the Kenya law reports before you, may I
By the way, mention
Switch your
my name. Mention my
Dr.
name.
Kamino.
Thank you.
My Lord, even the report of the East Africa Law Community confirms that. My Lord, the point I need to make, and I beseech you, because of the serious time that we had to prepare this application, I could only prepare for certain aspects of this application. My colleagues, Professor Gada, and my colleagues, Ndego and Jiro, within the 20 minutes that you have allocated, I will say my piece. It is insufficient, but I'll try. Please give Ms. Professor Gada and Mr. Ndego and Jiro 10 minutes each, and at the end, when we hear what the respondents are saying, you kindly give me, you need to indicate 20 minutes to do a rejoinder. That will enable us to be able to proceed without anybody feeling we want to be here forever. We don't actually want to be here forever. We want to deal with the business of the day. So that, that does not change any time allocations by more than 30 minutes. So I urge your lordship.
So who's starting?
I'm starting.
Okay.
Yes. So that I do 20 or gather 10, 20, because he has to deal with some authorities. I didn't get enough time. And it's under 10, then I'll do the rejoinder. My lords, the application that is before you is dated today. It is supported by the affidavit sworn by. It is supported by the affidavit sworn by Honorable David Muni Madenge. And for the record, all lawyers from Matiba, Ogada, Ndegwa, and myself, the record indicates we act for everybody without drawing any distinctions, because there will be no time for that. So we act for all the respondents, all the petitioners, for purposes of E015. My Lord, before going on to argue this application, there is a small point that I wish to make regarding the issue of why are we having a situation where to everybody watching we seems to be following an unusual path. My Lord, there is one substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations of the Bill of Rights. The petitioners are also here on account of the relevant provisions of impeachment. The petitioners are before you, my lords, on account of the fact that the business that the framers of the Constitution ordered, one, for appointment of a nominee to take place within 14 days, and for Parliament to do it within 60 days, somehow happened within 4 hours. My Lord, those are the principal reasons why we are here. And what is the immediate context? The immediate context, my lords, and why we are here is that when petitions are filed, the duty of this court under Articles 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My Lord, the way in which the law, and this is express positive law, requires that to be done is by way of a judgment. By way of a judgment is the only way that the people of Kenya would be satisfied. Have these rights been violated or not? In order to ensure that that judgment, which is the express constitutional mandate, is given in circumstances that are not academic, Article 23 of the Constitution provides that conservatory orders may be given. When this matter went before your brother judges, probably a sister also, in their wisdom, they directed this matter as such an omission that we need to preserve the subject matter. That subject matter, my Lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my Lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intendment of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My Lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, lift those orders so that I can carry those things that it is alleged I was unlawfully taking.
of the fact that what conservatory orders are supposed to serve. I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the applications. So that, my Lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, cannot be violated, even during an emergency. My Lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my Lord, I come to the prayers. The prayers are like this, and we had already indicated. There are about 6 substantive prayers. The linchpin of these substantive prayers, my Lord, is the fact that the Deputy Chief Justice